to the second case on this morning's docket. It's case number 106580, State of Kansas v. Sisson.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of Cornelia Sisson. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, just for way of background, this is a wind-up. No, it's a Saline County case.
Right.
I'm dealing with a car stop of my client, and upon search of my client, they found some marijuana and some scales, and they also found in the middle of the street some baggies of marijuana and cocaine. And so my client was charged with possession of the cocaine, possession of the scales, possession of marijuana in the street, and possession of the marijuana on his person, and no tax stamp. So the first issue in this case has to do with an instructional issue or a response, a judge's response to a jury's question in this case. And what's sort of interesting is we can kind of glean a little bit of what the jury concluded in this case. Often we can't do that, but in this case, we know that the jury convicted my client of, for example, the marijuana on his person, but acquitted him of the marijuana that the state had alleged he possessed that was out in the middle of the street. And so I think we can glean from that the jury formed a reasonable doubt about whether or not he possessed those items in the street.
And the theory on the items in the street was that he didn't stop immediately. There was a fleeing and a looting. There was a car chase, and the theory on the state is that he threw the stuff out.
That he'd thrown the stuff into the street.
Yeah.
But apparently
that was packaged similar to what was found on his person.
But apparently the jury formed a reasonable doubt about that, which is the standard. So we would think, well, we would be done with the possession of cocaine issue in this case, except the jury showed us, again, a little bit of what they must have been thinking, because they asked the judge, can we rely on this residue that was apparently found on the scales, which were found on my client's person? And so we had two responses as to why the judge's response to that question in this case were erroneous. First of all, that the state had never really pushed as a theory of their case that he possessed the cocaine on the scales. And when we look at, for example, the preliminary hearing testimony in this case, all of that testimony focused on the cocaine found in the street.
You don't dispute that was sufficient? I mean, the answer to the question was yes.
No, the second part of our issue in this case is no, that's not the correct answer. The correct answer should have been refer to, and in fact this is what the judge started to do, refer to the instructions, because residue can sustain a conviction if it's enough for you to knowingly control and possess it with intent. The answer I would have said is yes, if you find beyond a reasonable doubt that this amount that a chemist can't weigh or calculate, that a person can knowingly control and possess that.
It was tested positive for cocaine. There was evidence introduced at trial that the substance found on the scale was cocaine.
That's right. Unweighable, unusable amount. But yes. And so in these, I've raised this in other cases in this context of this argument, that I know that this court has said, and this is I think what you're saying, Your Honor, that this court has said any amount is sufficient to sustain a conviction for possession, that we don't have a measurement amount that's a requirement in the statute. And that's true, but we still do have a requirement that you knowingly control and with intent possess that drug. And I think a jury can form a reasonable doubt, and should form a reasonable doubt in most cases, if there's an amount that is so small that a chemist can't measure it. And chemists can measure things like to 1,000th of a gram. The chemist can't measure it. Do you really even know it's there? And so no, I don't think it's a completely correct answer. Yes, would have been a completely correct answer. The correct answer, at least, was the one the judge started to form in this case, which was the elements of it are knowing intent to control. But that's not what the judge did. The judge just gave a unanimity instruction in this case. So it's twofold. One, we argue that because it was really never charged, that cocaine on that residue was never charged, that the answer should have been no. The state's theory in this case is that it's the cocaine in the street. So the correct answer would have been no. Secondly, if you agree with the state that because the charge didn't specify it, that even then the judge should have at least given instruction that said, or at least referred to the elements of possession to remind them that residue, maybe it can be only if the person knowingly and with intent possesses it. So those are the two parts of our answer. That's two parts why we think the judge's response in that case was incorrect. Obviously, the defense attorney in this case didn't think he was defending against the cocaine residue. He said as much. And that was reasonable. We think about preliminary hearings. Sometimes we do bill of particulars, right? We do a motion for bill of particulars. And the answer is, look, if you can tell from the preliminary hearing what you're charged with, we don't need to do a bill of particulars. And in this case, when you look at the preliminary hearing testimony, the testimony was focused on the cocaine found in the street. That's what defense counsel thought the state's theory was in this case, and that was a reasonable conclusion on his part. Your Honor,
So was it wrong to give a unanimity instruction in this case, in your view? If a defendant if under our current law, a defendant can be convicted for residue, if the jury gets past the knowingly issue that you've talked about, there were multiple acts here, so actually a unanimity instruction needed to be given, and that part was okay.
yeah, I think that's right, Your Honor. That
Okay.
if you would hold that it was within what was charged here, and therefore it was just a multiple acts problem, yeah, I think you're right.
Thank you.
But it failed to address the jury's question, and the way it addressed the jury's question really failed, particularly in regard to that knowing and intent to control. The only other issue is that I'm going to submit issue 2 on the brief unless the court has questions, and then issue 3 is the very similar drug paraphernalia issue, which I don't have additional comments now on that, although my colleague might, that I would then respond to afterwards. That's all I have, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Good morning. I'm Cassie McIntyre with the Saline County Attorney's Office, appearing for the state. The issues in this case have been addressed by the Appellate Defender's Office. Specifically, the primary issue is what he has been discussing, the issue with this jury instruction. The state's position is that there was no abuse of discretion in the giving of the unanimity instruction. The Appellate Defender's Office clearly indicates that they feel that the court should have addressed the jury back to the original elements of the offense, which in effect is what they did. They basically said, you need to decide what you feel is the defendant possessed if in fact you decide he possessed any amount of cocaine. That does refer them back to the elements of the possession of cocaine, and in order to find the defendant in this case guilty of the offense of the possession of cocaine that was found on this scale, they would have had to have come to the decision that he did knowingly possess and control it. So effectively, by referring them back, the judge in this case, did refer them back to those elements, and they clearly found that they believed that the defendant did possess and control that. And since there was evidence presented at the trial that was in fact cocaine on the scales, it was testable, it was not able to be weighed, but the jury found that was sufficient. They found that it was on his person, they found that it was on the scales that he possessed. Clearly, I think that question was answered by the judge. It was not an erroneous application of the law. It was not a false statement of the law. It did answer the question. And in all honesty, the state's charging document was a little vague. It was ambiguous. We clearly had two possible items that could conceivably have been cocaine, that could conceivably have been possessed by the defendant in this case. And in fact, I think what we ultimately have is an attentive jury that really saved the state's proverbial bacon in this case, because they brought it to the attention of the court and to counsel that a unanimity instruction was necessary and needed in this case. Even without the unanimity instruction, I think the court could reasonably find that there was no doubt that the jury was referring to the cocaine on Mr. Sisson's person as the basis of the charge, because of the fact that they acquitted him on all of the charges attached to the items that were found in the street.
Were you trial counsel?
No, Your Honor.
Do we have transcribed closings?
I do not have them with me.
Okay, but they exist
Yes, Your Honor.
and they're in the record? Okay. So we can check there what the state argued in its closing on the possession of cocaine charge.
And Your Honor, the possession of cocaine, I read them last night.
Okay,
And
you
the
can tell
possession
me.
of cocaine charge, the state did not elect.
Well, they didn't say anything about the charge?
They spoke about the charge. They said that you should find him guilty based on the evidence
That was it.
presented at trial. They did not elect as to which theory or which type of
Well,
cocaine.
there wasn't, okay, that's fine. That's,
Right. As I said, it was very vague.
I was less concerned about the, whether they elected, given the fact that an instruction was ultimately given. I was more interested in whether at that point the state said you should convict him based on the cocaine in the street.
That was-
Just to, as directing them to that.
Right. And that's why I said the state's position on this case was rather vague. The charging document didn't specify, and it was not specified in closing arguments.
You mentioned the charging document. I just wanted to see that that carried throughout.
And it did.
Okay, thank you.
In the brief submitted, and I know it wasn't specifically argued earlier about the option of allowing the defendant in this case to be convicted of an uncharged offense for the cocaine that was found in his pocket. Once again, I would say that the charging document was ambiguous. And I do feel that if the court had not have given the instruction that it did regarding the unanimity issue, and the jury convicted, I think we would be right here today having the same argument that the unanimity issue should have been addressed because of the possibility of confusion on the part of the jury as to which of the multiple acts he was actually convicted of. And I don't have anything else on this issue. If you have any other questions.
What is your, why don't you, in a nutshell, tell us on issue 3, which I believe is the jury instruction issue, and that position that is raised, it was raised in the first case here this morning too. What's your position on that?
And Your Honor, I was surprised to see that State versus Keel was going to be heard this morning, since we cited that heavily in our brief. So that was a pleasant surprise. The instructions element regarding the paraphernalia issue, we would submit that is or was the pattern instruction at the time. There was no objection to that instruction at trial by the defendant, and it's not clearly erroneous. We feel that there's no real possibility of a different verdict in this case.
Is it erroneous?
Not clearly erroneous.
Not clearly, but is it error at all?
I actually don't believe so. I think it is distinguishable from Bryce in that it is once again, the pattern instruction. It's an instruction that is based on the statute. It gives a fairly lengthy list of items that are or could be paraphernalia. It's also not the only instruction in the instructions list. The other instructions say you also have to find these things to be true in order to believe that this is drug paraphernalia. If you take
At
it
the
that,
minimum,
sorry.
at the minimum, it's confusing in conjunction with those. other instructions, wouldn't you say?
I would agree that it is confusing, and I think that the directive language of shall is probably
Problematic.
inappropriate.
Yeah, that's the problem. The in an odd sort of way, because the statutes are so, at least attempt to be so inclusive about what can be paraphernalia, with definitions, including saying pipes and bongs, and that sort of thing. And I forget what it was here. I guess the scales, was it?
Yes.
It's odd. It's as though the legislature giveth and the legislature taketh away in terms of the elements of the crime, because paraphernalia has to be proven to be related to drug ingestion, but they also say paraphernalia can be these things, and they call it drug paraphernalia. It's peculiar. It's peculiar. I think it's the shall that gives you your problem.
Correct. But I think any reasonable person, if they saw that list and saw scales on there, they would not presume my bathroom scale to be drug paraphernalia merely because it's on that list. But a scale that's found in a pocket with drug residue on it, with a story that matched up that doesn't make sense with the crime and the circumstances, that a jury could reasonably conclude is drug paraphernalia. And the mere fact that it is one of the items listed in the complaint, it is in fact what we're alleging to be paraphernalia, the mere inclusion of that item on a list of things that can or shall be deemed to be paraphernalia as a non-exhaustive list, coupled with the other instructions that say you also have to find that it was used in conjunction with the ingestion or manufacture or any of those other things that deal with drugs. So not every scale is paraphernalia, just scales that are used in conjunction with drug ingestion. And the jury clearly did not believe the defendant's story that he had in fact just used those scales for measuring seasoning for his cooking. So they took that into consideration in the finding of the defendant guilty of that charge.
Do you have any further presentation for us today?
I do not, Your Honor.
Any more questions? Thank you, counsel.
Thank you, Your Honor. Or honors.
You reserve 3 minutes for rebuttal.
Your Honor, it's interesting as the discussion has gone along, Justice Breyer and my colleague, I mean, you've convinced me that, yeah, all other things being equal, if you said that this was included in the charge, yeah, I would probably be here complaining if there hadn't been a unanimity instruction given. So I guess the instruction given, I mean, wasn't legally incorrect, and I've never claimed that. But here was the jury's question. Are we considering cocaine residue of the scale as an amount sufficient enough to prosecute for possession? That was the jury's question. And my point is, even if it's correct about unanimity, and maybe it would have even been required, it's not a meaningful answer to that question.
Your argument is non-responsive. That's your argument. It wasn't helpful.
It's not
It
meaningful.
didn't answer the question.
In fact, you must find unanimously, this was the answer given, you must find unanimously as to which item they believe to be cocaine. I don't even know what they believe to be, I don't even know what that means actually. It's not helpful in response to the question asked.
I understand your point. But I'm not sure that you're correct when you said earlier on your opening portion of your argument, that the correct answer was, I think you said the correct answer was no.
No.
And I'm not sure you're right about that, because there was evidence to support cocaine in both places. We can argue another day about whether the amount on the scales was enough to be knowingly possessed, but there was evidence of cocaine in 2 places. There was evidence of 2 acts that would constitute the crime. So really the answer is not no either. It may not be yes, but it's not no.
When I say the
Wouldn't you agree?
No. The answer,
let's
when
see
I
if
say
we-
the answer is no, it's because I'm saying that it's not charged, that it's improper for the state. You're right that there's evidence of it, but it's improper for the state to rely on evidence for which they didn't charge. And our argument.
I thought we had kind of a general agreement among all of us that the charge was vague enough to include both acts.
The charging document didn't specify.
Right.
But our argument is that the way the state prosecuted this case through the preliminary hearing and its arguments, that the theory of and when we look at defense counsel who said, I was not on notice that the cocaine residue was part of the charge here. So that's our, so if that's the case, Your Honor, then the correct answer is no.
Okay, I understand what your argument is. Thank you.
That's all I have, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Clerk will take this matter under advisement. This time.